On the record, Councilmember Donovan is asking a question.
I'm finished.
Okay.
I'm done. Thank you.
Any other council members have a question for the witness?
I do, real quick. Ms. Todd, I'm looking at an August pay stub 2025 for you.
Could you please identify?
Yeah, it's 345, it's in 10. Under tab 10, exhibit 345. I just want to confirm, would you agree that the pay is correct? That the $1,201.60 is the gross amount that was paid to you?
I see, yes, gross pay $1,227.73, it says.
I'm just talking the regular, I'm not bringing up the overtime. Up top?
The 12 at 160,
Yes, you'd agree that's correct.
30 times, if that's what it equals out to be, if we multiply, yes.
Okay. You oversee Roger Breeding and Carolyn Chisenhall, correct?
Yes,
You also have the authority to fire them and discipline them, correct?
yes, I believe so under the charter.
Okay. And you're, outside of the chief, they have their own thing, you're the highest position, what we would call like corporate officer for the town, correct?
You mean pay-wise, or you just talking about?
Just the hierarchy, you're the highest there is, not bringing up the chief, he has
For
his
this
own-
side?
Yes, for this side.
I would say yes.
All right, thank you.
Any other questions from the hearing panel members? For the questions asked of the witness, raise any additional questions or issues for council?
None from council for Greenwood.
Okay.
No.
All right. The witness may be excused then. Thank you very much for your testimony. Does Ms. Todd have any other witnesses to present?
No.
Does that conclude then your case presentation for Ms. Todd?
Yes.
With party council agreement, we will move into closing proceedings. As part of establishing the hearing procedures, there was agreement to provide each party with a total of 25 minutes for closing argument. The town had previously elected to have 15 minutes for its affirmative closing statement, and then 10 minutes reserved for rebuttal. And Ms. Todd had reserved the full 25 minutes for her closing. The parties conferred and agreed on a different time frame for their closing statements.
Yeah, I think, I mean, I'm okay with 5 minutes each way.
Yes.
I don't,
Okay, then with that, does the town have any requests to split its time?
The town would like to reserve a minute for rebuttal, please.
Okay, so 4 minutes affirmative closing, 1 minute for rebuttal.
Yes.
Okay. Prior to moving to closing statements, are there any issues the parties believe need to be reserved or resolved?
None for the town.
Once the closing arguments are done, we'll make a few final closing statements, and then I will confer with the parties about closing the record and making sure that the record is what they want to be prepared and preserved for this proceeding. With that, since the town does still bear the burden, the town will go first with its closing statement. Mr. Polo, if you would proceed.
Thank you, Mr. Shapiro. The standard before the town is one of just cause. That means, is there more likely than not a conclusion that can be drawn from the evidence presented that the items in the notice of intent to terminate transpired? In order to satisfy that standard, there also must be a clear demonstration of the fact that there was an actual standard that Ms. Todd ought to have been held to. It's my position as the presenter for the notice that was issued that each and every single one of the items outlined in the notice have been demonstrated today by far more than a preponderance of the evidence. As my first point that I'd like to direct counsel to regarding this fact, I would introduce actually Ms. Todd's testimony herself. She agreed today, she conceded that she did not dispute that council had actually voted that a PKS representative appear, that the PKS representative was then directed not to appear. She agreed that she was paying herself overtime without receiving approval by any supervisor. And the one individual that she pointed to in her testimony who offered anything with respect to this proceeding, Ms. Jones, had nothing within the affidavit that was prepared ahead of time confirming that in fact there were any approvals of any sort. And so I would encourage council not to be distracted by the legal complexities of non-exempt and exempt under the FLSA, but simply look to the town's own handbook and conclude that yes, indeed, there's a requirement that supervisors approve, and that council as a supervisor ought to have been approving overtime and not allowing what has become a carte blanche process that frankly is a significant concern to the taxpayers. There's clear acknowledgement that there were emails sent involving personal favors and requests by an individual who had active business before the town. That is a violation likely not only of the clear standards in the handbook, but there are significant implications with the state ethics code. We also have considerations and concerns involving the manner in which Ms. Todd addressed items at council, getting frustrated during public meetings, and Ms. Todd also uncontrovertedly admitted that she did use profanity directly after a council meeting with an open door in earshot of others. I don't believe I've touched upon every single one, and I don't believe it's necessary for me to do so. I believe the evidence presented is overwhelming. I believe Ms. Todd herself has admitted to numerous transgressions. The final point that I'll note with respect to the audit is that in fact, Ms. Todd had clear responsibility either assigned to her by council or made clear from the flow-through responsibilities in the charter and the handbook. Records were not maintained, records were not reconciled, and so the town is left out of legal compliance because the town manager would like to simply point the finger at others and not accept responsibility for her clear obligations. I rest my initial portion of my closing.
Thank you. Mr. Poliquin.
Yeah, thank you, I appreciate it, I got a tough job here, right? I'm in you guys all requested to suspend her, and now, and you were the accusers of her, and now I gotta convince you somehow to say, no, we were all wrong, and change all that. But here's what I gotta say, okay? Good luck finding a new town manager. She was being grossly underpaid for what she did at $1,000 net pay a week. For all the work she did and all the dedication she did to this town after hours. By far, she got paid less for hours. She got paid much less for hours she worked than paid for any other hours of overtime. And one thing Mr. DeCalla doesn't mention is this investigative report. Know why? Because it's garbage. It's a hack job. No, it doesn't have any citations to any sources. It says multiple witnesses said, multiple documents said. You know what? If my sophomore in high school submitted a report, if any other attorney submitted a report and just said, hey, a lot of things say this, a lot of things say that, without any sources, we would get asked, we get thrown out of court. That's what you pay for your $20,000. Campanella testified that all the documents that he relied on are on is this big binder, this big hundreds of pages of binder, and that the documents showed that Ms. Todd was delay after delay after delay. There's not one document, the DeCalla's got a second, he's a smart guy, he can't point to one email that says Ms. Todd, it shows Ms. Todd delayed submitting documents to these people. Not one. And Campanella, your big witness, the guy who authored this report, the guy the taxpayers paid all this money to, all he can say is all these witnesses said, all these documents show. Where are they? They're nowhere to be found. This is what you guys have to relied on for this termination. This is what you pay for, an independent investigation, and you got nothing, okay? You don't see one where's the auditors here? Why weren't they called to testify? No, why? Because that presentation, they said, because there's nothing there. That presentation that they presented, they said, didn't say anything about her not complying with the audit. Not one thing. There's not one document here that talks about that. That's why they're shifting their theory of the termination. Well, it's because of this, because of that. Look at those auditor emails. There's not one that says, hey, you're not complying. It's fatally flawed and not credible. No citations, no sources, no attributes to any quotes equals no credibility. You guys cannot abide by that standard. This is not good enough to terminate somebody. and employment investigation reports must have clear sources and citations to establish credibility, objectivity, legal defensibility. They must cite in detail who said what, when, citing evidence like documents, emails, or recordings. Look at this report, it doesn't say anything. Caponella couldn't say anything. You can't simply state multiple witnesses said, these documents state, oh, there's a ton of documents, yet we don't have any of them. Because they don't exist. And perhaps Caponella didn't name the multiple witnesses because we're staring at them right here. Unfortunately, you guys are the adjudicators, right? Maybe you guys are the witnesses he's referring to, but that wasn't part of the report. Mrs. Todd is entitled to know her accusers. And we talked about this comprehensive overtime and wage report. Where is it? We don't have it. There's no way you can make a determination regarding that. The FLSA is an overtime pay is governed by a complicated federal law called the Fair Labor and Standard Act. It has a lot of regulations. It's got it's a broad scope. It's very detailed. And without this,
1 minute.
thank you, sir. Without this comprehensive overtime and wage report, comprehensive, yet we don't have it. Where is it? So the documents do not identify one instance where Ms. Todd refused or delayed producing documents. Big deal. She didn't notify PPS a week after. No, a month goes by real fast. You don't have an HR department. The auditor said you don't have enough people here. You don't have enough people working. And when you rely on one person, guess what? Some stuff
30 seconds.
isn't gonna happen. I got it, 30 seconds. Beautiful. All right, so there's no meat. There's a lot of sizzle, not a lot of steak. Your report stinks, the investigator didn't hold up, and you can't fire Ms. Todd over nothing. Thanks.
So to say that I am astounded at a description where Ms. Todd herself admitted to essentially all of the allegations issued, and that we're saying there's not a sufficient basis to process a termination, leaves me to say astounded would be an understatement. In fact, I would characterize the amount of information from Ms. Todd herself, setting aside everything else that you've heard today, probably amounts to roughly the 34-ounce porterhouse steak that I once tried to eat and couldn't consume. We're talking about a mountain of credible, significant evidence that Ms. Todd was engaging in numerous things and behaving in a manner as if she was the only one who had the authority, and counsel's authorization only mattered when Ms. Todd cared. It's quite telling to me that none of the exculpatory information that Ms. Todd took from the town was ever offered to Campanella, despite multiple proddings, and so that's why we have the price tag that was paid today. Instead of engaging in the investigation, we have what was displayed. I rest my case.
Thank you. My thanks to counsel, party counsel, for a very ably and hard presented case. I think you both did excellent job serving your clients, and you've given the panel members a lot to think about. With that, I don't believe that there are any other matters we need to deal with before we close these proceedings and close this hearing. Are there any questions about that before we close?
So the only wrinkle with that is that there is a requirement under FOIA if, well, I guess let me just back up for a minute. If we close the presentation of the hearing, I don't believe we can close out the council meeting yet, because Ms. Todd's requested a public process. And so I don't know that unless there's a basis to go into executive session to address guidance on how to digest the standard and so forth, which would be something that I believe the hearing officer would have to talk to the panel about. I'm certainly not going to do it. Then we would close the hearing, but not in fact close the meeting, and then close the meeting at the conclusion of their deliberations, if that makes sense.
I believe you're correct. I'm merely focusing on concluding the factual hearing portion.
I didn't eat lunch or dinner yet, so I might be a little bit confabulated, so I apologize.
I understand the porterhouse reference.
Thank you.
Okay. With that, we will conclude the factual hearing, and therefore look to close the record for the factual hearing. Are we now off the record?
Yes.
Okay. All right. We will deal with what we need to do in terms of the public hearing and whether you need to go into executive session and to handle that appropriately. I am going to once again encourage party counsel to be clear with the court reporter about what they need, want, and expect, and what they're prepared to pay for when it comes to the record, because I would like for her to be able to leave as soon as she possibly can.
Understood. I
need to put on the record.
Yeah, so I would suggest that the record that you're preparing encompass, if they go into executive session, I don't believe that can be in the record, but I believe that, when they come out and indicate how they decided, then that would probably be when you would reintroduce the recording so that we can have a coherent concept of what the outcome was today in one place. That's my thought.
I agree. What are we gonna do practically?
So then I have a question for the hearing panel.
We're on this record?
Yes. Is it panel's intention to deliberate and decide, if possible, this evening? Well,
Say that again?
Yes, I think that would be an
Okay.
agreement.
we will have the record reflect that the hearing panel is agreeing and sensing that their intention is to deliberate and be able to decide on the matter before it this evening. So we will adjourn into executive session. I don't have authority to call that. We'll let the town call that. And we will proceed to deliberations after advice and guidance that the council may request on application of law and fact. With that, are there other matters you want to deal with on the record regarding construction of the record?
None.
We'll just, we'll email the electronic documents, make the complete record, to the court reporter, is that?
Yes, and if you can place orders on the record.
Yes. In terms of, for the transcript,
Yes.
the town would like a copy of the transcript.
We're not
Normal, not expedited, like a normal rate of speed.
Thank you
Okay.
very much.
Sandwich.
We're not requesting a copy.
Okay. So then it's a practical question, or a practical matter, are we asking the court reporter to stay until deliberations are concluded and a decision is issued?
Regrettably, I think that's the only way to have the complete record that we contemplated.
Okay. With that, we now need to move into executive session.
We're off the record, public hearing is closed, yeah. So then I guess the next one is the executive session.
Entertain a motion to go into executive session.
I have a motion by Mr. Moran to go into executive session. Do I have a second? Seconded by Mr. Donovan. Let's vote. Mr. Donovan, how do you vote? Yes. Mr. Moran?
Yes.
I vote yes. Mr. Nelson?
Yes.
Executive session at 8:53.
We're not even close to my record.
Yeah.